Hello, we are staff from the Legal Resource Center on Violence Against Women, an organization that provides information on interstate issues and domestic violence. This online legal information clinic will address interstate issues, meaning moving with children from one state or tribal jurisdiction within the United States to another. The laws about crossing international borders with children are different and will not be covered today. Our presentation will help you understand some of the legal issues that you might face when deciding whether to move across state or tribal lines with your children. We will discuss criminal laws, relocation laws, and the Uniform Child Custody Jurisdiction and Enforcement Act, a law which determines where a custody case might take place. We will provide general information and answer some common questions. For direct legal advice about your situation, it is important to contact a knowledgeable attorney in your state.
How do I decide whether to relocate to another state?
If your spouse or partner has threatened or assaulted you, you may be thinking of leaving one state or tribal jurisdiction to go to a safer place. This can be a complicated legal decision if you have children in common with the abuser. You may wish to go somewhere safe within your state first, such as a domestic violence shelter or to a friend or family member's home, so that you have the time and privacy to learn about the laws. It is important to talk with an attorney who is knowledgeable about interstate issues before you relocate. There may be free legal aid or pro bono attorneys that can help you.
So can I leave the state with my children?
Maybe. This will depend on the laws in your state or tribal jurisdiction and the facts of your case. There are four major legal issues to think about. Number one, is there an existing court order regarding your children? Number two, what does your state relocation law say? Number three, what does your state parental kidnapping law say? And number four, where will a custody case take place? A good attorney can help you understand the laws in your state or tribal jurisdiction and how they apply to your situation.
Why does an existing court order matter?
If you leave the state with the children and you do not comply with an existing custody or visitation order, there could be consequences. The other party may file to hold you in contempt, meaning that they could ask the court that entered the order to punish you for disobeying it. The penalty for contempt could be a monetary fine, jail time, or even a change in a custody order. Also, if you do not comply with an existing court order, you may trigger another state law, such as a parental kidnapping law. Or a judge may be upset with you during a custody case if you did not follow a previous court order. If you need to, you can work with an attorney to get a pre-existing court order changed before you move. It is always best for a court order to reflect the reality of where the child is living and with whom the child is living.
Why does the state relocation law matter?
Most states have laws about what you need to do before leaving with the children, even if you are the parent who has custody. These are called state relocation laws, and they can be found as a separate law, as one part of a custody law, or sometimes in judicial decisions called case law. In some states, the state relocation law applies even before a judge has entered a custody order. An attorney can tell you about the relocation law in your state.
Why does the state parental kidnapping law matter?
Every state has some type of parental kidnapping law. In some states, it may be called a parental abduction, child concealment, or custodial interference law. This is a criminal law that says whether it is legal to leave the state with the children. In some states, it will be perfectly fine to leave with the children, while in other states, it could be a crime. Do not assume that what an abuser tells you about a parental kidnapping law is correct. An attorney can tell you what your state parental kidnapping law says. Some parental kidnapping laws contain protections for domestic violence survivors. For example, An exemption may mean that the law does not apply to parents who are fleeing from abuse or trying to protect their children. In other states, there may be a legal defense. In some states, you may need to make a good cause report or tell the police or prosecutor's office about the abuse before leaving. This may protect you from being charged with a crime later. It is important to talk with an attorney who understands domestic violence and your state's parental kidnapping law before relocating.
So do I need to tell the abuser that I'm leaving or where I'm going?
You can speak with an attorney in your state to find out, because it depends on your state parental kidnapping law and your state relocation law. If the abuser is likely to guess where you've gone anyway, telling them in a safe way or after you have left may give you some protection later, depending on the state. Similarly, providing for the abuser's continued telephone contact with the children, as long as it is safe, may help you later if the abuser claims that you denied them contact with the children. You may wish to keep track of when you made the children available for calls, as well as proof that you notified the other parent about the move.
Where will a custody case take place?
The Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, says whether a state has the power to hear a custody case about a particular child. It has been enacted by 49 states, DC, Guam, and the Virgin Islands. Puerto Rico and Massachusetts follow different but similar laws about child custody jurisdiction. And each tribe may have its own child custody jurisdiction law. The UCCJEA sets up a list of reasons that a state could have jurisdiction over or hear a custody case, pictured here as a staircase. At the top of the staircase is the child's home state, which has priority jurisdiction. The home state is the state where the child has lived with a parent or a person acting as a parent for 6 months before a custody case is started. So for example, if your child always has lived in Iowa, Iowa would be your child's home state and the proper place for a custody case to take place. If your child has not lived somewhere for 6 months right before a custody case is filed, then the courts will look at other possible reasons to get involved, such as whether a state has a significant connection to the family. Next, the third step of the staircase means that the state that has jurisdiction could give it up in favor of a different state that is more appropriate. And finally, the last step of the staircase, if there is no home state and there is no state with a significant connection, and no state has given the case up to a more appropriate forum, then any state can become involved. Remember, if your child has a home state, that is the proper place for a custody case to be filed. If you leave with the child, the home state will still have the power to hear a custody case if the other parent files there within 6 months after the child's departure. Because of this, you should check regularly, about once a week, to see whether the other parent filed for custody after you left. In most states, you can find out by contacting the family court in the county where you have left. The abuser may not tell you the truth about whether a case has been filed and could misinform the court about where you are.
Do I have to come back to the home state?
Maybe. There are 3 possibilities. Number 1, in some cases, a judge in the home state may order the children to be returned. Number 2, a judge may allow you and the children to remain in a refuge state, even if the judge decides to keep the custody case. Then it will be important for you to be a part of the court hearings in the original state, either by returning in person or by asking the judge's permission to participate by telephone or video conference. Number 3, the judge may decide to transfer the custody case to the refuge state. No matter what, the important thing is for you to be able to participate in the case as early as possible.
Can I file for custody in the refuge state?
If you have relocated to a new state, after 6 months, it will become your child's new home state, assuming that nothing has been filed back in the original state. Once there is a new home state, a court in that state can hear a custody case about your child. Now, if you just arrived in a new state, a judge there can exercise emergency jurisdiction. This is a temporary decision that a judge can make when there is an emergency. It can be helpful in domestic violence cases or where the children have been abused. Many attorneys and court clerks, however, may not be familiar with emergency jurisdiction, so you may be told incorrectly that you need to wait 6 months. The UCCJEA says that a judge can exercise emergency jurisdiction where necessary if a child or a sibling or a parent of the child is subjected to or threatened with mistreatment or abuse. That means that if you have fled because your partner abused you, the judge in the refuge state may enter a temporary custody order, even if the child themselves has not been physically abused. You would need to prove that there has been abuse against you and that there is an emergency. Emergency jurisdiction only is a temporary solution, and the child must be present in that state. You can decide with an attorney in the refuge state if filing for emergency jurisdiction makes sense for you.
Should I get a protection order before leaving the state?
Many people think about filing for a protection order before relocating. A protection order may stop the abuser from using violence, or it might improve the police response if you call. In many states, a protection order can help by awarding temporary custody and child support to you, removing weapons from the home, or requiring the abuser to leave. A protection order also can help document the abuse for future court proceedings. And if you get a protection order, it will be enforceable all over the country. However, there are some risks to getting a protection order if you wish to relocate. It may be harder to leave the state if your protection order includes a specific visitation schedule for the other parent, for example, because you would need to comply. An attorney can help you understand the pros and cons of filing for a protection order before relocating.
What should I do before leaving the state?
When you separate from a controlling or violent partner, it can be a dangerous time due to separation violence. With an advocate, you may wish to create a safety plan. A safety plan is a common sense plan tailored to your particular circumstances, trying to reduce the abuser's access to you at home, work, or places you typically go. In the About Abuse section on womenslaw.org, you can find safety tips for specific situations. Follow any advice you received from an attorney in the original state, because state laws about parental kidnapping, relocation, custody, and protection orders vary. And also, be sure that you are aware if the abuser has filed for custody in the original state. Usually, you cannot leave with the children after one parent has filed for custody.
How can I ask the original court to transfer a custody case?
With help from an attorney, you may decide to ask a judge to transfer a custody case to another state or tribal jurisdiction. There are 8 factors that a judge must consider, including whether or not domestic violence occurred and which state can best protect the parties and the children.
What if the abuser has taken the children to another state?
If you do not have a custody order, you may need to get one so that the police can help you retrieve your children safely. If there is an existing order, you may be able to ask the police in the abuser state to enforce it. Or you might need to go to court in the new state to get a pickup order from the judge before the police will get involved. Sometimes another option is to file criminal charges against the abuser for violating a parental kidnapping law in the original state. At other times, these cases can be resolved informally by working with the abuser's family if possible to negotiate a safe return of the children.
How can I find a lawyer to help me in an interstate case?
You can contact your local legal services program, which may represent domestic violence survivors for free. You can also contact domestic violence shelters or advocacy programs to see whether they have an attorney on staff or can recommend other attorneys in your area. Or there may be a law school nearby that has a legal clinic for family law or civil cases. Sometimes your state domestic violence coalition will have good referrals for attorneys. Or you may wish to contact local family law firms to ask whether they have a pro bono program where you can get a free attorney. Finally, some of the best referrals may come from other survivors who have worked with attorneys in your area.
What should I say when looking for an attorney?
Although you may have a lot to share, when searching for an attorney, it helps to be brief at first and then to respond to follow-up questions. It is important to explain the severity of the violence as soon as possible so the person you're talking to understands the danger you face and wants to help. We have included an example on the slide. You also can visit the womenslaw.org page on choosing and working with a lawyer for some other suggestions.
So what should I prepare before meeting my attorney?
You can help your attorney understand the case and save money by preparing items in advance. You may wish to compile a journey with the history of abuse against you or the children, including dates, what happened, whether the police were called, and whether medical treatment was needed. Any evidence of abuse could be useful, including photographs of bruises, prior protection orders, police reports, medical records, a list of possible witnesses and what they could say, 911 calls, court transcripts, text or email messages, and social media threats. To help your attorney figure out which state can handle the custody case, you may wish to create a detailed timeline of where your children have lived, including the states and the dates that the children live there. And if you keep track of your questions, you may bring them to your meeting and ask your attorney's advice.
What resources are available?
For direct legal advice, you can reach out to your local legal services programs or domestic violence victim advocacy organizations. On this slide, we list some national resources that may be able to offer general information, but not direct legal advice. The Legal Resource Center on Violence Against Women focuses on interstate custody and domestic violence issues and can provide technical assistance to an attorney who may be representing you in an interstate case or referrals to you. The National Center on Protection Orders and Full Faith and Credit can provide general information about enforcement of protection orders across state and tribal lines. The National Clearinghouse for the Defense of Battered Women works for justice for victims of battering who are charged with a crime where a history of abuse is relevant to their legal claim or defense. And womenslaw.org has state-specific information on custody and other family law issues related to domestic violence. You can also ask a legal question through their email hotline, where they can provide state-specific legal information. We wish you the best of luck as you navigate a path to safety.